Hello, my name is Samuel, and I'm here at the Virginia Museum of History and Culture, and I'm going to be interviewing Elizabeth Johnson Rice. She was a civil rights activist and a part of the Richmond 34. And I'm going to be asking her what were the ramifications of the sit-in they did and how it affected culture and society in Richmond. I'm going to interview Ms. Rice at a lunch counter where an actual sit-in happened. As an aspiring lawyer and judge, this will help me understand the judicial branch and how different types of protests can alter our society. I've heard that you were a civil rights activist, so can you give me insight, what did you fight for?
Back then, we could go to the department store, but you couldn't eat at the lunchroom counter if you looked like me. We could go buy the clothes. You couldn't try them on, though, if you looked like me. So that was the duality of the world at that time. In 1959, when I came to Virginia Union, things were buzzing around the campus because there'd been the sit-ins there in Greensboro. And we knew it was coming to Virginia. And so we had been trained by Martin Luther King how to be in a nonviolent movement. There were two leaders of the sit-ins. Frank Pinkston and Charles Sherrod were ministers in the School of Religion, and they said, we need to make a statement. We're going to march down today at Thalhimers Department Store. What started out as a small group of students ended up being over 200. We were hearing the horns, people calling us names. But if you were trained, you knew that you had to not respond to that, to keep your composure, to represent the school, represent your family. The leaders said, we're going in. My brother and I were in the store when they cut it off at 34. We took our seats around the counter. Some took their books and they were studying. I didn't have any fear. I just knew I was doing something that I really wanted to do. And I saw the police wagons pull up with those big old German Shepherd dogs with the chain. They said, you're going to be arrested for trespassing if you don't leave now. So that was the charge.
So after the sit-ins, what were the legal ramifications you guys had to face?
They took us to jail. They fingerprinted us. They took my picture. Then we were there for about 40 minutes, maybe an hour. The bailiff comes out and says, you students are free to go. Your bail has been paid. Well, my goodness, how did our bail get paid? 34 of us. But as we got to the door, we heard all this shouting and laughter. People were lined up down the street, just so proud that the Virginia Union students were out of jail and that they didn't get, beat up or hit. So it was like a celebration. There are people behind the scenes that made the difference. It was a unified movement of people from all kinds of backgrounds that came together to make a statement.
Now that I've heard a first-hand account for one of the members of the Richmond 34, I'm heading to the United States Court of Appeals for the Fourth Circuit. I will talk to Judge Roger L. Gregory in order to learn more about the legal impact of the Richmond 34 case. We know they did protests, they did sit-ins, but what is the legal side of these sit-ins? What happens after they do these non-violent movements?
Because of their protests of segregation by race, they had to face the penalty of a criminal charge. They didn't run away. They met what the due process is. They were found guilty. They appealed to the Hustings Court, which is now the Circuit Court. They were found guilty. And then they went to the Supreme Court of Virginia and they appealed there. After it went to the Supreme Court of Virginia, it was appealed to the Supreme Court. And there you get into the real context of what the Constitution was meant to protect, the idea of justice and freedom and dignity.
As you said, the Supreme Court reviewed the case. Well, how was it solved? How was the case dealt with?
They vacated the conviction and then they remand it. The remand means that when it goes back to the state court, you have to look at this case now in light of our precedent. And that came from the process of called judicial review and supremacy, going back to Marver v. Madison. When the court rules, the court is supreme in that regard, and the state had to abide by it.
What can students like me take from the Richmond 34 case?
Thalhimers fully integrated less than a year later, and then the '64 Civil Rights Act. But that happened because young people stood up and said, this Constitution belongs to us. I think it was Brandeis who said that the highest office in a democracy is not a presidency or a big title. The highest title in office is citizen. Only you and I can build bridges. And those bridges are built by our faith and our commitment to that incredibly powerful and wonderful idea of justice under the rule of law.
Overall, what I learned today is that nonviolent protests can lead to bigger social and legal changes. The Richmond 34 case is a good example on how we have a court system that can review laws and change them for our benefit.